Up next, we are going to learn about constraining LLMs with graphs. How many here know what a graph is? And do you think it's one of these things with a hockey stick? You're going to get your mind blown if that's what you think it is. Zarja Hude is from the London School of Economics, and she's going to talk about the project she's been working on that combines neural and symbolic AI to model legal reasoning, much like we heard in the last panel, with foundations in legal theory. So, Zarja.
Yeah, thank you so much for having me. My name is Zarja Hude, and I'm a second-year PhD student at the London School of Economics. Today, I will talk about graph-constrained LLMs, and the subtitle would probably benefit from being explained backwards. So I'll talk about the legal reasoning, meaning the substance of law. I'll talk about neural-symbolic architecture, where I combine the LLMs as a neural component with the knowledge graphs as a symbolic component. And I'm doing that to approximate the legal reasoning process from the legal perspective. As you will see in the following slides, many of my design choices are grounded in jurisprudence. But before we get there, a bit of background. My research is motivated by the limitations that have proven to be an obstacle to fully trust the LLMs in the high-stakes legal domain. Importantly, they are opaque. One cannot understand how the decision was made, and that stands at odds with the requirements in the legal reasoning that requires you to explain pretty much everything. Secondly, they are non-reliable, and there are two dimensions to that. The first one is that if you give them the same question, you cannot be 100% sure that they will give you the same output, which may not be a big of a deal anymore for day-to-day tasks. But when we speak about the legal reasoning tasks that are very complex and may involve tens or even hundreds of steps, and sometimes the characterization depends on the borderline cases, not on the mainstream, the LLMs still don't perform as good as you would want them to. And to give you a bit of perspective on that, the research in the legal AI with the LLMs exploded in the last few years, but the community has existed for much longer. And what the previously legal AI community was focusing on was the symbolic AI. The easiest imagination of that would be the legal expert systems. And when comparing the symbolic AI to the limitations of the LLMs, these systems are explainable, meaning that you can trace back the decision to the very original source, and they are deterministic. So if you have a certain combination, permutation of factors, you can be sure that you will always receive the same answer. But, however, these symbolic AI systems were struggling because they required a lot of manual effort to be created in the first place, and even once they existed, it was really difficult to scale them, if not impossible to do that. And these are the two limitations that are promised to be overcome by the LLMs. So there is a natural fit to combine best of both, right? We had a panel on that. Yesterday we had a dedicated workshop on that specific topic. So I'm not the first one presenting and proposing that perhaps we should find a way to combine neural and symbolic to hack the legal reasoning process. And there are many different ways to do that. So the taxonomy here is taken from a keynote speech on the AAA conference from some years ago. And on the side are the references of the research papers in the legal AI space that I came across. And the main point of these slides is that there are various ways of doing it. This is a very active research area, so most of the papers on the slide are coming up from the very recent years. And thirdly, there is at present not an unanimous consensus on what the best combination of both would be. So when I asked myself the question a year and a half ago when I started my PhD, I very quickly bumped into very difficult questions, because if you want to create a legal AI system, one has to wonder what is the rule in the first place, what is the legal norm, what is the legal concept, what is the law. And that invited me to revisit what I was learned in my first year undergrad, so the very fundamental jurisprudence that underpins the law. On the slide, we have the picture of a gentleman called H.L.A. Hart, which is one of the most prominent philosophical figures. And today I'll be focusing on part of his philosophy that is relevant for part of my research, which is his theory of adjudication that is on the right side of the slide. In essence, in the Hart's time, that was in the 1960s, the philosophers were trying to figure out how the judges should be deciding the cases. And there were two extremes that existed at the edges of the continuum. On the one side, there were strict formalists who were saying that it is on the legislator who should specify all the rules to the sufficient detail so that the judges can mechanically apply them without using any discretion whatsoever. Whereas on the other side of the extreme, there were rule skeptics who were saying that one can never foresee all the possible situations that can occur in a real-world scenario. So it is really this contextual understanding of the case that gives the authority to this decision that the judges made. And Hart, back in the days, rejected both these extremes and proposed a more balanced approach. In essence, he was saying that in law, most of cases can be resolved by using the rules alone. This is what he called are the easy cases. However, because we are using the natural language as a medium, and this is subject to a so-called open texture, there will always be some margin of uncertainty. The example that he was famously using is what qualifies as a vehicle. It is straightforward that a car is a vehicle, that's easy, but whether a motorized wheelchair qualifies as one is trickier to answer. And in these Hart cases, Hart argued that it is on the judges to activate their discretion to fill in the interpretive gap, not arbitrarily, but bounded by the rules. And this essence of his philosophy is incredibly helpful if you are trying to figure out how to combine the neural-symbolic methods, because you can simply change the rules with the symbolic AI and the discretion with the neural component, which brought me to a proposal to combine the neural-symbolic methods in a way that you use the symbolic framework to constrain the LLM reasoning. And this proposal earned me the runner-up prize at the Doctoral Consortium of International Conference on AI and Law last June in Chicago. The prize gave me the confidence to go a step further and try to figure out if what I'm proposing actually works. So what I did next is that I took work done in the 1980s by a lady called Anne Gardner. She had a PhD from Stanford Computer Science Department and LLB from Stanford Law School and received the 2024 CodeX Prize, I believe. And on the slides, we see part of her work, which she did in the 1987. So she created a computer program, back in the days purely symbolic, that was able to reason over a limited segment of a contract law. The left graphic is her knowledge base, and she used the technology used back in the days called augmented transition network. And on the right is her analysis, which produced different interpretation of the same scenario that she was analyzing. So what I did is that I reconstructed her knowledge base into a Neo4j, which is a property graph. So the property graph allowed me to attach the properties, so the additional contextual elements to both edges and the nodes between them. And I integrated the LLMs at the different stages of the reasoning pipeline, where I deemed that aligns with the Hart's philosophy to be invoked when the knowledge runs out. This is just a snapshot of the architecture, which is very simple. I was really focusing only on the integration between the LLMs and knowledge graphs at that stage. So once I had the system built, I inserted the same input that Anne Gardner was using. So it's a narrative of the communication sent between the buyer and the seller, and the end question is whether a contract was formed. And then I compared the results of my system to the results that Anne Gardner derived. So whatever is in the light green matches her analysis precisely. Whatever is in the dark green is what, after my review, was assessed that it could also be argued. So I'm a pure lawyer by background, and that's why the dark green is what I stand behind, that is also a correct answer. Whatever is red is an error. Whatever is pink is a propagation, the consequence of that error. And whatever is white is what should be detected but wasn't. And everything that is green was deemed correct. Everything that is not green was deemed as an error. So I ran the analysis 12 times, and my system achieved the result of 89%, which may not sound that high, but when I ran the very same analysis over the pure LLM baseline, and I used the same LLM as I used in my neural-symbolic system, the success rate dropped to less than 9%. And as we can see, the main issue was that the LLMs were collapsing the nuance of the legal reasoning into one single most plausible narrative, and even that narrative was not the same in all 12 analyses that I ran through. which led me to conclude that if you do use the legal knowledge to guide and constrain the LLMs, you may derive significantly better results for the legal reasoning task. An additional benefit that is not visible from here is that I was able, because of the knowledge graph architecture, trace back the errors, do the error analysis, and analyze the reason why the error was made, which is not something that you can do with the LLMs. And coming up with this earned me another prize, this time the best paper at the doctoral consortium at the URIX conference. This is the Conference on Legal Information System in December in Turin. And now I'm spending my time trying to build the knowledge graph that could support such neural-symbolic integration on the UK tax residency test. So if that sounds somewhat interesting, feel free to reach out. Thank you.